We're live. I am 3 minutes late. Are we live? Can you guys tell me? Are we live? Do you hear me? Let me know if you hear me while I charge my phone. Hello. Can y'all hear me? Got 8 people in the chat. I expect 8 likes. That helps us. Helps the algorithm see the live stream. Thank you. Hello, Buchanan. Hello, Anish. Anish. I hope I'm pronouncing that correctly. Hello, May HM. Thank you for letting me know you can hear me. I'm wearing my pink corduroy tuxedo today for you all. It does not fit. It does not fit at all. Check my mail. You can start absolutely. You can start asking questions. Let me check my mail for. I do not want to. I don't know what I'm checking my mail for. I don't say anything, and it's okay. What have we got? Do we have any questions? Hello, Mustafa. How are you? YouTube user Anish asks us, what if your employer asks you to resign after complaining about harassment, then terminates you for your beard 2 weeks later? Okay, so did you complain about general harassment, sexual harassment, or some form of discrimination? Complain about general harassment, all of this is a bit of a moot point. It's just generally not going to be a claim. But if you complain about sexual harassment or some kind of discrimination, I would say the termination is retaliation. Additionally, I would say, well, at least I would ask you, if your beard was of some sort of religious significance to you, if it is religious or cultural significance, if it is, that could additionally be a claim for religious discrimination or national origin discrimination in certain settings. Oh, shoot us. Yeah, thank you. I agree. Our videos are raw and unedited. We are going to keep it that way. But I appreciate you. Thank you for the pitch. Buchanan asks us, can I file under Section 1981 if my employer discriminated against me because of my ethnic religious beliefs? If you're in federal court, you probably can, but you would not want to leave out the additional claims, the statutes that specifically deal with that sort of thing as well. So yeah, you would include 1981 potentially. You would look at 1981, 1983, and you know, go with what's appropriate. Anish, it sounds like you have a sexual harassment claim, a discrimination claim, and potentially a religious accommodation claim, but certainly a retaliation claim. May HM pretrial conferences. I don't think you need to go. You're welcome to go. It's your right to go if you want to go. But unless you have some reason to distrust your attorney in her or his abilities or intent, I would say don't worry about it. Anish says, can you be terminated for a company known error internally with operating systems? Anish, you can be fired for any non-discriminatory reason or no reason at all. So if it's a pretext for some form of discrimination or retaliation, that would be a claim. But if they're legitimately firing you because they're blaming you for some kind of internal error, that sounds legal. Unfair, gross, but legal. Mr. D says, I have a question. The corporate general counsel that I've been dealing with has been basically ghosting me after asking me to destroy evidence. Thank you for making that video, by the way. Any suggestions? Yes. File. Hire counsel and file. You're being ghosted because you have not done either of those things. Matthew asks us, how does your firm select failure to hire cases? I submitted a potential case to your firm, but did not receive a call back. Matthew, I don't know why you would not receive a call back. Did you talk to the call center? Or did you submit an email inquiry? Sometimes, and we try to keep this from happening, but the volume of contact we're receiving is incredibly high, and it is actually overwhelming the call center sometimes. We have a call center down in King of Prussia, PA, and they've had trouble staffing up with bilingual staffers to handle our call volume. So that could be what happened. Or, Matthew, you may have said something that was utterly unappealing in your inquiry. Sometimes people say wild things. I'm not saying you did this. I have no idea. But people say wild things in their inquiries, and we don't call them back because we don't think we want to talk to that person. I'm sure that was, if anything like that happened with you, I'm sure it was a mistake. I'm not saying that's what happened with you either. I have no idea. Mall Cop says, how likely is a judge to reduce a jury award for emotional distress damages when the jury is giving the exact amount you asked for at trial? It depends, Mall Cop. It depends on if the judge feels the jury properly applied the law, right? That it's going to be a jury instruction, and if the jury followed it very closely, then your emotional damages verdict should be more likely to be safe. But judges do often reduce emotional damages awards. And each says they tried to file a disability leave before the write-ups, which they denied. Sounds like a claim, certainly. Yvonne says, hi, new subscriber here. I received a probable cause against a volunteer fire department with the New York State Division of Human Rights, and one of my witnesses passed away. What happens when death occurs? Okay, so if you have any written affidavits from that person, you can use them. But in the absence of some kind of written evidence or written affidavit from that person, unfortunately, that person is, sadly deceased and can no longer testify for you. And also impressive that you received probable cause against a volunteer fire department. New York State has been very aggressive towards volunteer based discrimination. Although I do know volunteer fire departments are different because they give out medical sometimes and some amount of pay or pension, things like that. Noriega, one of the last ones, says, what is the benefit of your attorney writing about your case on the firm's blog site? Is there an upside to that, or is it just typical? I would actually say it is atypical. It is not normal, but I don't know there's any upside about that. This might mean that your attorney is excited about your case, which is a good thing, right? Like if your attorney is writing about your case, that must mean that your attorney thinks your case is interesting and novel and of interest to people, and also that your attorney believes your case will go really well, because they wouldn't write about a case they expect to lose, right? Anish goes on to say, I tried to file a Family Medical Leave Act leave for my anxiety and stress, which I told them about. It's on paper and email before asking to resign, before they ask you to resign. Yeah, that sounds like sounds like you have a solid foundation for a claim there. I think your claim sounds good. DFS 21 says, will a back or front pay calculation be more favorable if I'm currently employed versus still being unemployed? I might receive a job offer soon, but it's $30,000 less than my previous pay. Okay, DFS 21. So a couple of considerations here. If you take employment, it can stop your economic damages growing, or in your case, where you're $30,000 less, it can slow the rate of growing. You would still be growing at the pace of $30,000 per year, but all the other money you're earning, you receive less. That being said, you do have an affirmative duty to mitigate. However, that affirmative duty to mitigate is only applicable to truly comparable jobs. So a job that costs you $30,000 less may not be comparable, right? Now I got to take this corduroy jacket off here. Can I turn the camera off for a second? Is that an option? Do I have to do this? All right, we're just gonna, doesn't fit me. There we go. All right. That was embarrassing. Anyway. Okay. What do we have here? Mr. D says, I've been looking for an employment attorney ad nauseum for 2 months now where I live. Rhymes with same. And 95% of the firms here don't do employment law. The others are both solid. Mr. D, then I would recommend checking with some of the national firms. Without recommending any of these people, there's Gloria Allred, there's Morgan and Morgan, there's a firm out of Southern California, Shimolensky, something like that. There's our firm, but I'm not pitching our firm. there's national firms. So if you don't have any firms where you are, potentially, that you might need to speak to the national firms. KM says, my attorney said they won't consider taking my case until I reach the lowering of my salary to 50% since I am on leave from effects of sexual harassment and the company is not responding appropriately. And you go on to say, is that normal? I would say that is normal, but I hate it. Listen, there's two things going on there, right? So the case needs to be valuable enough that they can afford to invest in it. So if they win it for you, they can make their money back and profit, right? And I agree with that. That being said, like, I don't know what's going on there. A lot of times, if I think that I could win a case, but I would win less than $40,000, I will decline the case because I can't then spend freely on that case. And I don't want my people shortchanging a case because it's not valuable enough, right? So we have good people here and they wouldn't do that. But it's hard telling a young associate, hey, you've got these 10 cases that are all worth minimum, 6 figures, we think. And you got this case over here that's worth 20 grand or 30 grand. And we're going to be watching you to make sure that you work them all equally. And they're like, well, yeah, but I can't really make money on that one. We're just going to lose money, right? So it can be hard. I kind of understand where they're coming from, but I hate leaving sexual harassment cases unrepresented. It drives me insane. Respectfully truthful deleted their message. Oh my goodness. Larissa Dirkswager says, can I file a charge in the state court with a firm located and the incident occurred after I moved out of state and changed my driver's license? I don't see why not. Unless there's some special rule in the state that you're talking about, certainly that would be appropriate. Yes. Generally, the best venue is the venue in which the state in which you work. Comex M258 says, can an employer deny employment to a candidate with a conditional offer if the candidate has pending criminal charges, but the candidate claims to be innocent, even if charges are dismissed later? It depends on the state right now, I believe. So in New York State, no. But in some other states, yes. The federal laws are less interested in pending charges than they are in criminal records, right? So if you have convictions, the federal laws are much more interested in that. Respectfully truthful asks, does EEOC mediation typically lead to a settlement? It often does. Typically is a strong word. EEOC mediation will often be a step towards settlement, even if it doesn't settle the case in that day. Remember, this is a field where you have I mean, I don't know about other firms, but I think our caseload, like 98%, north of 98% of our cases are resolving without trial, right? So settlement rate is very high. Tony Greer says, hey, Vincent, faced racial discrimination, segregation from a sidewalk, and retaliation. Can I pursue my claims under Section 1981 of the Civil Rights Act of 1866 versus Title VII? So was this in the course of your employment? Because I can only answer employment questions. But generally speaking, I'm going to assume it was in the context of employment. You don't have to choose between Title VII and 1981. Like, you can bring a federal lawsuit with both of those claims. It's not an either or. It's more, right? Like, so wherever you are, you're going to bring all the federal claims that are valid. You're also going to bring all the state and local claims that are valid, all in that same federal court action in most jurisdictions. I like that, by the way. It's not either or. It's more. Maybe it's not that good. I like it, though. I enjoy it. Cam says, so the case is potentially worth more as soon as my salary goes down. Cam, every day that you're not receiving your salary, your economic damages potentially go up. Now, also, every single day that you're receiving a less than your old salary, it still goes up, but it doesn't go up by as much, right? So if you're receiving, let's say you were unemployed for 3 months. Well, I would argue your economic damages are the max you would have earned over those 3 months. And then after 3 months, you find a job, but as you noted, it's $30,000 less per year. So from that point on, you're earning an amount, but you're still adding to your economic damages for the difference going forward. Yvonne, happy to help. I hope I did. Bubblegum says my old employer lied and said I was on corrective action. I was able to show proof that they wrote the corrective action the day they fired me. Will that increase my damages? Well, I mean, it gives you access to potentially retaliation claims, which could give you some punitive damage, which could raise your damages. Kicking off my shoes, getting comfortable. Supposed to help move our new log cabin chicken coop, our second chicken coop here today, but it's pouring rain, so we didn't do that. Anish says, do you have to say the word discrimination or is letting them know you have stress and anxiety enough? Anish, if you had a diagnosis of stress or anxiety and asked for an accommodation, that would certainly be enough. If you did say discrimination, that would be even better. If you didn't do any of that, but talk to them about disabilities like anxiety conditions and stress, that could also be enough. It's not really a standard of saying the magic words. It's more in terms of what you say. Being, how people will view it and how it will be construed, and will it be protected activity? Will it be seen as protected activity? Tony Greer says, by the way, thank you so much for what you do. You're helping so many people. I hope so. I hope I like it. I got to be honest. This feels super silly more often than not. So, listen, I really hope I'm helping people. Thank you for saying that. Cam says, really want to work again, but not feeling that environment is safe. Yeah, don't, Cam. If you're not, I mean, a different employer is not going to be unsafe, I would presume, or maybe I don't know what you're saying. But also, you don't have to take employment that's not comparable, right? Michelle G says, love the channel, just stopping by to support the live, and congrats on the 100K subs. Thanks for all the great info. Thank you, Michelle. Thank you. I was super excited about the 100K. It made me really happy. I get a little plaque now from YouTube. It's ridiculous, but it makes me happy. I don't know why it makes me happy. I think it's because I'm a really big fan of YouTube, and I've lived through creators I like getting plaques, and I was excited for them. And now, a decade later, I'm getting a plaque for 100,000. I'm like, oh, this is amazing. For me, it's fun. May HM says, the defendants in my case submitted 15 defenses to the court. Is this typical number of defenses for a discrimination case? Yeah, they're going to put in as many defenses as they think have merit. They're going to leave nothing out for two reasons. One, they're billing by the hour, right? So the defense counsel is going to bill by the hour. They want to do as much as they can. Two, they don't want to leave anything on the table. If they have a defense that even might work, they're going to throw it in. All right. MS72 says, I reported discrimination and retaliation to HR before being laid off. How does my 1 year tenure in company size 500 plus employees affect the claim for damages I can collect? Doesn't affect the size of the claim, is the simple answer. You're big enough that you certainly qualify for the federal laws. I would imagine you qualify for your state and local laws as well. You being there 1 year, not a major factor in my mind. Company size, not a major factor. Once you're over 14 employees, company size doesn't really matter to the valuation of claims. It matters to the behavior of the defendant in a lot of ways, but not the valuation. Respectfully, Triple says, I gave up 2 months of sick leave. I could have used the time to increase my retirement. Would that be taken into consideration if there's a settlement? The settlement is whatever you accept, right? So if you hold out for consideration on the 2 months of sick leave, and if they agree to it, then yes. If you don't hold out, or if they don't agree to it, then no. Settlement is completely freeform. You can ask for any legal term, and they can agree or disagree to that, right? Thank you for saying that, Sue Jones. Sue Jones says, thank you so much. Your videos help us all. Bubblegum said, thank you. You're welcome. Can you recommend an attorney in the UK? I cannot. I'm sorry. We only deal in the US. If I knew someone, I would certainly recommend them. I can actually give you the name of 2 incredibly bad attorneys in the UK who got their faces kicked in recently, but beyond that, no. And that's not a statement about all UK attorneys. I'm sure they're amazing. I'm sure they're the same as US attorneys in terms of the spectrum of their abilities. I just recently had dealings with 2 who I was not impressed, and the results matched that. Not in their favor, I should say. Malcop says mediation in a week. Trial beginning of June. Wish me good fortune. I do wish you good fortune. I wish you great success. I wish you a fat check and a righting of all wrongs. May HM says, I found a discrimination case on Pacer. My previous employer settled. Is the only way to learn about the details of that case for my lawyer to contact their lawyer or the plaintiff? It depends what you're trying to find out. What you're trying to find out could be on the docket, could be on Pacer, or if you're trying to find out the settlement, that settlement, depending on the state, could be confidential, right? So even if you contact the attorney or the plaintiff, they may not be able to tell you. You could subpoena them to try to find out under the argument that you're trying to set a pattern, and then you would perhaps defeat that confidentiality, but that's a speculative and uncertain and expensive endeavor, which may or may not be worth it for you. Matthew says, is it sufficient to provide dates and a generic no action taken as proof that the defendant was on notice of discrimination during the complaint to avoid dismissal? Well, if you're showing they're on notice of discrimination, you need to show, that they knew or they should have known about the discrimination. The best way to show that is that you complain, right? You can proof that you complain. If you're saying provide dates, if you're saying provide dates of your complaint, then sure, that's a great start. Excuse me. My new professional microphone that YouTube user John Doe recommended does not have a mute button anymore, so I cannot conveniently mute it if I cough or anything. It is a great microphone, though. Very happy with it. Thank you, John Doe. QG Grand says, I wanted to say hi. I'm currently in settlement negotiations with 2 national insurance carriers. I have having a jolly good time. I am glad to hear that. I also love your vibe on that. Having a jolly good time. Good for you. Cuppy J says, I'm in a state that recording needs 2 sides consent. I recorded for myself. My employer denied every claim. Can I use recording in court because they lied that they did not say those words? Listen, that's an in-depth question. And listen, maybe your attorney can get it in. Maybe your attorney can get it in. I can see a world in which your attorney gets it in, but it might be an uphill battle. Cam, my pleasure. Cam says, thank you for everything you do and for this opportunity. My pleasure. Must Be Heard says, thank you for this. My pleasure. Wow, there's so many new names and new faces on this. This is awesome, guys. Thank you so much. If you don't mind, remember to like the stream. It helps people see the stream. XX says, Vince, you the man. I'm pretty mediocre, but thank you for the kind words. Festus says hello. Festus Imafidon says hello. John Doe, oh, congrats on 100K. I remember when you only had 2K. Thank you, John Doe. I also remember when I had 2K. I remember when I had 20. I think I got 20 on my first day because I launched the channel and some law firms that didn't like me started watching the channel to see what I was up to. It was so I immediately had 20 people viewing, and that was back in 2013. But I believe I sold that YouTube channel. I kept the videos, so they kept the videos and they still play the videos with my likeness in them. I guess I don't know. But I also kept the rights to those videos. So I took those videos, and in 2016, July of 2016, after I started my new firm, after I got cancer free, I launched a new channel with those videos. Candidly, Kristen says, how are damages calculated if you take a job in a city that pays higher salaries and higher cost of living? Concerned that damages are only considering the gross amount despite net income being lower. Okay, so if you win your trial, you're going to have a damages hearing. It's a bifurcated process most of the time in this field, especially if you're in federal court. So let's say you win. It sounds like you're thinking about going to trial. Candidly, Kristen, that's what it sounds like to me. Let's say you win. Is there static? Mimi T, is there static? Let me try to turn the fans down here. Are you still hearing static, Mimi T? What if I let me know if you still hear static? It's also raining here on a hot tin roof, so maybe that's an issue. Okay, let me go back to Candidly, Kristen. It sounds like you're considering going to trial. If you win the liability portion of trial, meaning that you win and the jury agrees with you that you've been wronged and your claim should go forward, then there will be a damages hearing, and you'll have dueling economic experts, assuming your counsel is doing everything right, which will argue as to what the damage calculation should be. Part of that argument will be that you took a mitigation job in a city where the pay is higher, and they might have some wrangling to do about that. But I hear you and I agree with you. I don't know if you're going to capture that difference in settlement, but you might capture it if you go to trial and the economic experts duke it out. John Doe KCK says, so what's up with businesses in New York City using remote workers on the other side of the planet, to the work of in-person cashiers, which completely undermine minimum wage and everything else that protects workers? Yeah, John Doe, I think you're referencing the Amazon instant stores or whatever, which actually I used to go to. We would just walk in and like throw things in your basket and then just walk out and be charged like automatically. There was no cashiers or anything. And they used to claim that like artificial intelligence was doing that, but it turns out that artificial intelligence was doing less than 40% of that, I think. And that mostly it was people in, I think it was India, watching the video and then correcting the AI to charge you correctly. Now, 2 points on that, John Doe. One, obviously I agree with you. That undermines the local minimum wage. However, there are fewer and fewer and fewer people in New York who can work at that level of employment because New York is so expensive. So a lot of populations are being driven out of New York, right? So there's almost no unemployment. And let me put it this way: almost no one who would like to work in New York is unemployed, or no one who can work in New York is unemployed, right? The second point there, and this is interesting. So Amazon, if I understood correctly, made the argument that the individuals in India were not so much doing the work of the cashier, but they were correcting the AI to train the AI. I do not know if that's accurate or not. That is Amazon's claim. I would never make Amazon's claim for them, but if that's true, that's very different. Sean Pova says, hey Vince, love your content. Thank you so much. XX says, free views, ha ha ha, haters gonna hate. Thank you. John Doe says, hey Vince, can you sue an employer who's incorporated in New York even if you live and work out of their office in Georgia? Yeah, you can. You can certainly sue them in Georgia. If you work in Georgia, you can sue them in Georgia. Sounds like the static is not fixed. That's concerning. That might be here. Let me try something else. Is that better? Is the static better now? I'm using the really nice external audio card that YouTube user John Doe recommended to me. NYC damages. What would be the best tips for pro se and EOC process to get them to do mediation within the EOC? I mean, you just have to agree to mediation, right? You could Ask the investigator to tell the employer that you would be reasonable and that you want to engage in good faith and you want to negotiate in good faith. But it really comes down to, if you agree to mediation, you will get a mediation if the employer also agrees to the mediation. It's that simple. CE 81 says that I drink too much Dunkin' Donuts. No, CE 81 says I filed an internal claim and I was laid off. The unemployment paperwork showed it was due to lack of work, yet they posted a new position in the department the same week. Can they change their reason if it's documented? So they're clearly trying to do a switcheroo here. They terminated you under a pretext and then tried to paper it. You're just going to have to prove, hopefully you have some proof of your internal claim, right? You complain of discrimination or sexual harassment internally, or like unpaid wages, something like that. You're going to have retaliation protections, and that would certainly be a claim. QG Grant says the consistency of your uploads is insane. Keep up the hard work. Thank you. I've got my videos posted through Monday right now. I did recently, over the last month, miss a few times, and I felt horrible. Like it. One was just like I had to take the video down because the audio had been corrupted or didn't work, and so that no video went up that day. And then I think I missed like 2 days in the past 30 days. And every time there's no video up, I feel horrible. I feel like I'm letting you down. I don't know why I'm laughing. That is sincerely how I feel. May HM says, my lawyer formally requested a jury trial. Awesome. I would say you almost always want to do that. And that the defendants pay the maximum punitive damages. His damages assessment maxed out at $300K. Can there be caps on punitive damages? I mean, there could be caps on punitive damages depending on what statutes you're using. If you're talking about like Title VII, realistically, no. It's up to the discretion of the jury. I mean, there's some notions, but like they don't want to put businesses out of business and stuff like that. Okay, so I'm seeing there's still static. There's still static. Let me scroll. Is there still static? Oh, less static. Okay, so like I can make the static go lower by turning down the pickup on the microphone, but then I think I get too quiet. Am I now too quiet, or is this okay? Oh, John Doe, then I am misunderstanding what you were saying. Oh, I missed some questions here. I better go back. Respectfully Truthful says there's rain or static. I don't care about background noise. Appreciate you. Thank you so much. Very kind of you. Jupiter James says, hello, Vince. Are awards or rulings in arbitration less severe to the fact that there are no juries or public scrutiny? Like, say, can punitive damages be awarded in arbitration? Happy 100K, so well deserved. Thank you so much. The Jupiter James, first let me say, so I work as an employment arbitrator, and I don't think that my awards are significantly lighter than jury awards. However, I will freely admit, and obviously my awards are in situations where I really believe the plaintiff and I find for the plaintiff, right? I'm not in any way saying that I'm biased towards the plaintiff. I'm a plaintiff's attorney. That's where I came up. But when I work as an arbitrator, I am fair and impartial. Now, and also I'm fair and impartial because I've seen both sides of the industry, right? Like I've seen people try to hire me just clearly lying, right? Like that's, and you don't want to give those people money, right? Like that's not good. That's bad for society. It's bad for everybody. That being said, I do think, statistically speaking, that arbitrators tend to apply the damages calculations more accurately than juries do. I also think that arbitrators tend to be attorneys who work in this field. So employment arbitrators are generally employment attorneys. Not always. Some employment arbitrators are judges who never really worked in this field. Excuse me. But either way, whether you're a judge or an employment attorney, defense side or plaintiff side, you spend a career attaching dollar figures to horrible hate crimes. And that can jade you. Like I think I've used the example on this channel before where I was once listening to a young woman who had been horribly sexually harassed. And as part of the sexual harassment, her assailant bent her partially over a fryer, and her face was burned. And in one of the moments of my life in which I was the most disappointed in myself, I can remember in my mind attaching dollar figures to what I was hearing. And that's my job. That's my job to an extent. That's what I have to do for her. But I wasn't hearing her as a human being. You know what I mean? Like that's something I can do if she asked me to do it. But really, in that moment, the thing I should be doing is being like, "Oh my God, are you okay?" Right? And clearly, the answer is no. You're not okay. You can't. Those kind of things are horrific, and she lived through so much, right? And I recount that story because I think that that predisposition, that jaded nature of an employment attorney, where they hear horrible things happening in the workplace and attach dollar signs to it and value it in their head, that is professionally what we're supposed to do, what we're trained to do. But it sometimes doesn't make for the shock and awe jury verdict that you might hope for, which is also unlikely to be substantiated, right? Like, so the huge verdicts out of juries, they can be huge, but are you going to collect them? Is that going to get appealed? Is the judge going to cut it down? Right? Like that's also something to consider. Going after the big jury verdict, are you going to collect it? And even if you do end up collecting it, how many years did it wait in appeals before you got it? So there's a lot to think about there, right? John Doe. Then I did not know what you were talking about. So John Doe says that there are restaurants and such doing it now. So basically, John Doe saying that there are restaurants in New York using cashiers out of, I guess, the Philippines, who's on the screen interacting with you. And that's fascinating. I mean, I think a big part of that is that New York, I forget, I think the minimum wage for fast food is like $25 an hour now, which, listen, I'm always a fan of paying workers more, but having like a one industry minimum wage is kind of wild, because then you end up in situations where like EMTs and social workers get paid less than people working at McDonald's, and that's very strange in a variety of ways. But also, like, listen, I want workers to earn more. So I would say that perhaps that this is a perverse consequence, an unintended consequence of the New York City minimum wage laws for fast food. I'm not at all surprised that they have people out of the Philippines doing video cashier work. That makes perfect sense to me. Sky Beach says the EEOC investigator stated today that they would be sending a notice of right to sue and that I have 90 days to file. Can I individually file a lawsuit before 90 days and then find an attorney later? You can. I would urge you not to do that. That's an emergency move. I would urge you to hire counsel ASAP and to get the case filed, because in filing pro se, filing on your own without counsel, a lot of times you will do damage to the case. Even if you do an amazing job and you don't do damage to the case, a lot of attorneys won't take the time to read what you filed, and they'll just assume you did damage to the case, which sucks because they make it really hard to get representation. So listen, that's a great option, filing on your own, if you can't find somebody in 90 days. It's worth noting that 90 days runs from the day you receive that right to sue letter, not from the day you were told you're going to get a right to sue letter. So you have a little extra time, but not too much. And also you should document when you receive that right to sue letter. But yeah, if you can get representation, you should before you file. Hannah Fields asks, can I file in federal court with a P.O. box address so that my address is not public? Hannah, I'm so sorry. I don't know. I've never had to deal with that. As I always had a law firm address to file from. I don't know, Hannah. I'm sorry. If you contact your pro se support office, they should be able to tell you that answer. And if they can't, if you contact the pro se support office and they legitimately decline to answer your question, let me know. I will assign an associate to do a research project for you, and we'll find out. And they will never forgive me for having to do unpaid research. John, channel jumps ahead. Whoa. John Doe says no. Can you sue them in New York? Possibly. If you can, did your employment ever cross into New York in any way? You might be able to sue them in New York. Yo Cannon says, is it possible for an employer to modify hours worked without getting caught? I'm worried they might attempt to destroy evidence. I mean, anything is possible, right? It depends. So, like, you're going to get forensic IT at some point in discovery, assuming you're represented, and you should be able to catch them if they modify hours worked. But also, you should be able to get like your locational data from your cell phone company, your geo data, whatever it is. There's a lot of things you can pull to prove you were at work at a given time. Your swipe ins, if there's a swipe card, maybe you have witnesses. There's so much you can do to prove when you're at work. Candidly, Kristen says, I echo the sentiment of chat. Thank you for all you do. You have helped so many of us, and your accessibility is unparalleled. Thank you. You guys are really making me feel nice today. Thank you so much. Okay, so we still have background noise. I'll keep working on it, guys. I'm sorry. I'm trying. There is rain. Like I have a tin roof, a metal roof, and there's pretty heavy rain today, so that might be it. Has there been background noise on the videos over the past week as well? Ask and Answer says, after more than a year unsuccessful job search, can you use efforts to start a consulting business to mitigate your losses? My age and my non-citizenship status, green card holder status, impair job search efforts. I don't see any reason you couldn't start a business as long as you're allowed to, based on your immigration status. And I know nothing about immigration besides my own immigration story. So, yeah, you could certainly open a consulting business. I don't see why not, as long as it's allowed. Sean Pova says, what happens after you complete an arbitration trial? How long does it take before you get an answer from the arbitrator? Generally, Sean, I like to give a decision within 2 weeks. The longest I think I've ever gone was 30 days. And generally speaking, arbitration moves far, far faster than any court. The whole vibe with arbitration is extra expertise, more efficient, moving faster, and more confidentiality. Whoa, channel jumping ahead. John Doe. Okay, so I think I already answered this, but I'll try to answer this again because the question's more fully asked here. John Doe asked different John Doe. There's John Doe with GAWN and there's John Doe with JOHN. Can I sue an employer incorporated in New York courts if my job and office is in Georgia? New York juries are likely more advantageous. I agree with you that New York juries are more likely advantageous. So there's a number of ways you might be able to argue that New York, is the proper venue. Your employer will fight you. There's a decent chance the case gets removed to Georgia if you have not crossed into New York City in the course of your employment. If you've crossed into New York City in the course of your employment, even though you normally work in Georgia, if you had like a business trip in New York or New York City specifically, you activate the New York City human rights law. And the New York City human rights law is it like proselytizes. Like if you cross into New York City, in the course of your employment, you likely get access to New York City human rights law. Great example would be like if you work for an airline, you're a female flight attendant for an airline that primarily flies in countries where they want you to dress with a certain dress code that may be, frankly, not really that appropriate to force a woman to wear. And you cross into New York in the course of your flight path. Well, you can get off that plane, you can walk over to a law firm and say, I'd like to take advantage of the New York City human rights law and file myself some sexual harassment and gender claims. And even though like 1% of your employment might only have been in New York City, 1%, and that could be potentially enough for the New York City human rights law. We have Respectfully Truthful says, have a great weekend. Thank you. You too. Congratulations on 120 subscribers. Thank you so much. Okay. KM says, can a family member sue on behalf of someone who died by suicide due to a large part to harassment and bullying at work? KM, generally speaking, harassment and bullying are not what I would call very viable claims in the workplace in the realm of employment law. That being said, there's claims like intentional infliction of emotional distress, and I think there's at least one state with an anti-bullying statute in place. So if you are the trustee of that individual's estate, I think you could, right? So I've represented people who died during our litigation, and the caretaker, the trustee of their estate, took over as the client and worked with us, and we did the trial in the absence of our client, which was super hard because star witness gone. But we were able to get a little bit of money for the estate, and they distributed it to the beneficiaries, I think is the phrase. I'm pulling up my bar exam recollection. I never really worked in that field. John Doe KCK says, would you plant giant sequoia trees at your farm? I don't think I would plant giant sequoias. I don't know if we get, I don't know if we have the right soil or the right environment for giant sequoias, although I would certainly look into it. Like, those trees are super cool. Right now, in terms of trees, I am in 2024 bringing in about 30 Hokkaido, which is the northernmost island of Japan, cherry trees in alternating pink and white blossoms. And I'm going to be lining, my driveway is quite long because it's rural. And I'm lining my driveway in those cherry trees, which are well suited to the cold environment that we have here. I think I've already brought in, so we did a bunch of apple trees last year. We did cold hardy kiwis. There's a kiwi berry. It's smaller than an actual kiwi. But it can grow in our cold zone, which is great. So we have a pergola with the cold hardy kiwis, peach, plum, pear, like bringing in a lot of that. I'm really building out the orchard this year, because when you're building an orchard, like, first year for roots, second year for shoots, third year you get fruits, right? So like whatever you do, you're building it out super far. But that's probably not, I like talking about that, but that's probably not why any of you are here. Asmari says, can you talk about how one can pursue defamation against individuals within a company that are not human resources supervisors, potentially coworkers and clients? Sure. So you would go with whatever state you're in, you would look up the defamation laws, and you would see what the elements of the defamation claim are. If you feel that what you experienced fits those elements, I'd recommend going to hire an attorney. That attorney will probably want to charge you hourly. Defamation claims are generally not all that valuable unless you have a lot of fame or like brand loyalty built up, something like that. So they'll want to charge you hourly, but it can be done, and you can file against just an individual walking around. It doesn't have to be HR, it doesn't have to be your boss or the principal of the company or anything like that in most states. May HM asks, is it typical for a defendant to cite the Fifth Amendment in a civil case in their response to the court? So it's not typical, but it happens. I've seen it happen. So of course, what May HM is referencing is when a defendant who is testifying, or even just a party who's testifying under oath, pleads the Fifth. What this means is, I'm not going to answer that question because it could incriminate me in a criminal matter that is either pending or which could come in the future. So in your position in May HM, if that's happening, that means that there might be some other criminal action, or they fear some criminal action, and they don't want to answer the question because their answers could incriminate them. Now, that is obviously not a great move for them in terms of your case, because now the judge is looking at them like, you probably did something pretty bad, right? So that's, that's not great for them, but they might have bigger problems, bigger fish to fry, so to speak. Sky Beach says, can an employer legally fire you for not being able to answer the phone or talk to management while very sick? Sky Beach, it depends on the sick leave laws of the state you're in. And also it depends on things like if you have sick leave left over, right? Like if you have no sick time or leave time left, maybe, depending on the state that you're in. Let's see. Matthew asks us, can I be hired as part of a settlement claim on a failure to hire case? Yeah, you can ask to be hired. I've certainly seen that happen. I've seen employers just be like, actually, we're just so in the wrong. We'd love to have you. Can that be one of the terms of the settlement agreement? And I've had clients say, sure. And they go to work and maybe they get 20 grand in addition to that because they got the job. So it's just not, you certainly can. Oh, sorry, New York City damages. I think I did answer this question, New York City damages. But I'll answer it again for you. Let's read it again to make sure you hear the answer. New York City damages says, I think I was skipped. Do you have any tips for a pro se to talk to the defense attorneys in a way to get them to be open to talk? Oh, no, I didn't see this one. I thought this was the mediation one again. Do you have any tips for a pro se to talk to the defense attorneys and a way to get them to be open to talk with the pro se during or before the EEOC mediation? So I think the magic phrase that I would encourage you, because defense attorneys don't have the thick skin or the sweet suits of plaintiff side attorneys, right? Like they picked defense because they want the guaranteed money and they want the white shoe law firm experience, and they don't want their clients to like be individuals with thoughts and feelings, right? They want their clients to be institutions that don't care because that's way easier, right? So if you can convey to defense counsel, hey, I'm just looking to have a calm, rational, good faith negotiation. I think you have some liability here, and I think my ask is pretty reasonable. Can we have a polite back and forth? I fundamentally understand as a plaintiff that you, defense counsel, are not the person who did the bad things. You're not the person. You're the person I need to speak to about resolving this, and I appreciate you for that. So let's have a good faith negotiation. That is my recommended approach. Anish says, Vince, we found out they hired me with my beard and stubble and always had positive reviews about it on my documentation. They reviewed your beard in your documentation? That's wild. It must have been a pretty sick beard, dude. It was never an issue until I started complaining about harassment and stress. Yeah, so I think the beard is probably a pretext, but I also think there could be additional claims there. Thank you, Mimi T, for letting me know. I will continue working on eliminating the static if I can. Is my microphone too quiet now? Because I've turned down the pickup on the microphone. Candley Kristen says, put your DNA on that like button. It helps all of us. Thank you, Candley Kristen. Likes do help the channel spread. My other channel says, after I was terminated, I've been looking for employment, but considering that I am 61 years old, the cards are not dealt in my favor. Getting a bit frustrated knowing that my chances are thin. So I got to say, I had this conversation, and listen, I'm 41, which is great because I thought I was 42 for most of this year. I forgot how old I was. But my grandfather retired, I think the first time at like 59. And he went back to work at 63. And then he retired again a couple years later. And he went back to work in his late 60s. And then he kept working on and off until he was like 82. And I got to tell you, he never had trouble finding employment. And he was not taking small time jobs. He was taking like sizable logistics positions. And listen, he definitely made it. Like he was a logistics guy. He had a career with IBM. I've never forgiven IBM for the way they pushed him out, which was definitely age discrimination for the record. But he then worked in California. He worked in Venezuela when Venezuela wasn't quite so wild as it is today. He worked in Siberia. He worked in Poland after the Iron Curtain came down. He worked in Kazakhstan. He taught logistics in China at one point. He moved a manufacturing process to Taiwan, all of which he did after the age of 63. He was globetrotting, working like a beast all throughout his 60s and 70s. So, listen, different industries are different. Certainly, I agree with you. I just don't think you should count yourself out. That's all I'm saying. Mr. D says, at what point? Oh, we got lots of questions. Whoa. Mr. D says, at what point do you cut ties when negotiating with defense counsel for your former employer when they just give you the runaround claiming they need to talk with their boss, yet the boss is MIA? You got to push forward. You got to. So before law enforcement folks got really excited about putting their knees and feet on people's necks, which I guess they were always doing, but I used to say things like you got to put your foot in their throat. You got to apply some pressure. But now I guess that doesn't play quite the way it once did. And we've seen some people die that way. You got to put some pressure on them. You got to file. You got to move forward. You can't just keep waiting and waiting and waiting. That's not going to work. Oh, thank you. Thank you for letting me know NYC Damages about the sound. I am still working on the sound, certainly. Hopefully the sound in this is better than it has been. Anish, then it sounds like pretext. I would go with it. QG Grant says, how much faith should you put into an opposing attorney as a pro se litigant? Take what they say with a pinch of salt or a pound. I mean, it depends on what they're saying. If they're telling you the date of the next appearance in court, 90% chance you can trust that. If they're telling you your case is worth $5,000 because of right, I would not even listen to that noise, because that person their job is to get you to settle for as little as possible, right? KM says, during the period of sexual harassment at work, I had a business trip to New York for 1 month. Can I file my claim in New York instead of London, where I am employed? I would think you probably could, as long as it's still timely. I would check with an attorney in New York and see what they think. But I think you might be able to bring that claim in New York. Noriega, one of the last ones, says, have you ever had a case where, as the employer intentionally tried to intimidate an employee from going forward with bringing a harassment, discrimination, retaliation case against them? Yes. I have worked on cases with pretty wild intimidation. Worked on cases with nooses being hung around the job site. Worked on cases where cooling vests were deprived to people who were trying to go forward with claims, which was incredibly dangerous. You could die. Threats. I've seen threats against employees. I've seen people's siblings get beat up. I've worked on cases where these things have happened. I've seen cars sitting outside of clients' homes. I've received threats. Um, lots of like weird mailings, um, mailings with powder in it, stuff like that. Which is I hate saying that because that the comedian from I think the show is Patriot Act who like made up lies about getting like dangerous powdered substances in the mail or whatever. Like I hate talking about that stuff because like so many people try to do it for attention. But yeah, I mean people in these cases, stuff can get wild sometimes. We've had to talk to staff about like, listen, this is a pretty high profile defendant, lots of money, pretty aggressive. You're like having an affair. Now's a pretty good time to go somewhere else because you may not want this smoke, right? Like they're going to hire PIs, they're going to out you, and they're going to get leverage on you, and nobody cares. We're not turning back, right? So yeah, certainly seen stuff like that. John Doe KCK says a stand of 5. A stand of 5 what? I think I missed what you said. A stand of 5 giant sequoia? Oh, Team Tahoe says, Vince, I had a despondent attorney, probably defendant's attorney or respondent's attorney, who didn't include me during the EEOC process. Oh, maybe you did mean despondent. I had a despondent lawyer who did not include me during the EEOC process. When the NRTS letter came out, she had an overloaded caseload coming out of CV19, so she dropped my case. I mean, that doesn't fully matter. You still have the right to sue letter. You could still get filed in a timely fashion. May HM says, thanks, Vince. Congrats on the 100K subscribers. Please post a video of you hanging your gold plaque. Do I get a gold plaque for 100,000? Or do I get a silver plaque? I don't know. We're going to find out together. OC House says, congrats on 100K. Thank you so much. Thank you also, May HM. Team Talk host says, my attorney didn't inform me that I received my right to sue letter, so I was forced to file pro se last minute. No time to find counsel, and now no one will take my case because I filed pro se. Conundrum. It is an evidence-heavy wrongful term case with PRET. Did you finish that thought? So, okay. So, Team Tahoe, have you looked at our elevator pitch, like how to find an employment attorney video playlist series? Because you might be able to make a more appealing version of your case, like a really short, like one pager of your case, and pitch it that way, and hopefully get the representation you need. That would hopefully get you what you need. I hope. Question from Ray O, YouTube user Ray O: is it possible for an employer to destroy evidence that could prove them to be in the wrong, such as misplacing emails? It's always possible. Certainly, people try. Discovery is a big part of holding them accountable. Forensic IT and e-discovery is an even bigger part of that. Lots you can do on those fronts to catch them in things like misplacing or deleting emails. Nolan says, hey, Vince, hope you're well. Thank you. I hope you're well. Message the Alien Goddess says, Alien TV, Alien, whatever. I don't know. Mr. Monopoly, Alien, Eyebrow, Alien, Mr. Monopoly, Alien, Mr. Monopoly. John Toe, thank you for letting me know we're not too quiet. I appreciate that. Heads up, I have 22 minutes left. I'm cutting short at 5:30 p.m. Eastern time today. We'll run a full hour and a half, but we are cutting it short. We're not going 2 hours today. In New York, if COMEX M258 says, in New York, if a national employer rescinds an offer due to pending charges, and they double down and say that's their policy, would a disparate impact discrimination claim be possible? Is it a class action? Well, I don't know if it's a class action because I don't know to what extent they might have done that. But yeah, I would think you have a claim. Certainly. Mimi T says, the microphone is good. It must be the fan. Thank you for your time and info. Thank you. I think it is the fans on the computer. I bought a huge computer to do these videos on because it has huge hard drives and like tons and tons of fans, which is probably overkill. But it's got tons of fans. Tons and tons of fans. Somebody keeps opening and closing my garage door. Why? Why is that happening? Excuse me. Nolan says, if I reported FMLA violations to the Department of Labor, open an investigation, and the remedies offered by the company are crap, and I do not agree to them, do I forfeit any rights to sue in federal court? You could, I believe, confirm this with the Department of Labor, but you could end your Department of Labor process and go on to federal court. Is my understanding. Confirm that with the Department of Labor, because they could sometimes they get funny and try to hold on to things, but as long as they're okay with it, I don't see any reason you couldn't go to federal court. OC House says, a coworker injured me at work and I reported him to the police. He was cited for disorderly conduct. My employer tried to have me sit down with the man who hurt me to work things out before it got ugly. Excuse me. What was the... Oh, we went on. OC House goes on to say, after my coworker injured me, my employer asked me to sit down with him to work things out, even though he wasn't allowed to be around me because of a no contact order. I assume an order of protection. I never sat down with him. Good. I respect that you never sat down with him. I'm trying to find if there's more to your question. Okay. Nolan says, by the way, the audio problems are probably from that neon sign in your background. Cool sign, though. I agree. Thank you. So turning it on and off doesn't seem to make a difference. Like when I turn it off, do things get better? And I always thought it was a neon sign because the audio problems did crop up about when I got that neon sign, which was ordered from, I think, Ukraine. So let me know if the audio problems go away when I turn the sign off. Anish says, what happens if you catch a witness lying in a deposition or during litigation under oath? Are they credible in court? I think it's a great way to attack their credibility in court, right? If you catch them lying during a deposition or just on the stand, that's a tremendous opportunity to attack their credibility. Team Tahoe says, first female director of HR retaliated against and filed protective complaints according to no avail. I survived them all. Motion to dismiss with claims, discrimination. That's awesome. I applaud you very much so. Yes, Anish, Hassan Minhaj. And I actually really think Hassan Minhaj is funny. I think he's a talented comedian, but I do remember being very disappointed in him when he was like faking receiving white powder and like claiming that he like dropped the white powder from his mail on his child, which I think was all just entirely false. And he came up with some weird theory, like it was emotionally true, which I'm like not phrasing correctly. I'm sure he would do better stating what he meant. But like, I got to be honest, like the guy, like his comedy, but I was not impressed by that stage of his career. Let's say, super talented guy though. Team Tahoe. Lawyers acknowledge the merits, but will not touch the case because I'm already so far into the process. Thoughts, suggestions. Thank you in advance. Whew. Ooh, look at that. I'm sweating over here. So, Team Tahoe, I'm trying to think. Maybe you could sweeten the pot a little bit. Like if you have some money, maybe pay a law firm like an upfront retainer to get them onboarded and be like, listen, I understand it's going to take you a lot of extra work because I filed pro se. You're going to have a lot to do here to get things back the way you want them for litigation. I would pay X amount of dollars up front and then also give you a contingency. Maybe that would sweeten the pot and get an attorney to get past the idea that you filed pro se and there's a lot of rehab work on the case and get them to get involved. John Doe, listen, if you can tell me where to purchase giant sequoia, I would love to do a stand of 5 giant sequoias. I would probably I would probably do them at the base of my property to screen my property from anybody down on the highway. What do we have? Cuppy J says, my attorney got a right to sue letter, which will expire after 300 days from a state agency. I have not filed suit yet due to still being employed. Can I still file a discrimination suit after termination if it's over 300 days? So I don't know what state you're referencing or what the right to sue letter says. So I'm going to answer your question as if it was an EEOC right to sue letter. Your EEOC right to sue letter encompasses everything you filed in your EEOC claim. And it can encompass everything that's reasonably related. But let's say you receive a right to sue letter from the EEOC, you have 90 days to get filed. And you wait those 90 days, you don't file. But then the day after, you get terminated. Not a problem. Because the termination is now a new discrete act of either retaliation or discrimination. You can file with the EEOC again, get another right to sue letter, and file for the termination. The thing that's unfortunate is you lose, under the federal law at least, what came before in the earlier right to sue. Now, I don't know which state you're referencing, and I don't have like an encyclopedic knowledge of every state's right to sue guidelines. Excuse me. So I can't answer that question, but that would be how it would operate under the federal law. Regina Johnson says, hi, Vince. Happy Friday. When will you be hosting your next live question and answer? I would think 2 weeks from now. I would think 2 weeks from now. Certainly. May HM says, we use the harassers. Oh, hold on. I skipped a question. Nolan says, would it be considered age discrimination if a company's efforts to encourage resignation included making work assignments too hard for a person over 40? Yeah, potentially. I mean, if they're targeting people over 40, employees over 40 to try to force them out, that would potentially be age discrimination. If the age is a reason why they're doing it. May HM says, we use the harasser's full name in the complaint. Good. Always recommended. And I am having some concerns about this for my safety if we go to trial. Can the complaint be modified to hide the person's name? I mean, you can have that conversation with your attorney, but realistically, not that much. But there might be something they could do. It doesn't hurt to have the conversation with your attorney, right? Your safety is important. So have the conversation. It makes sense to have the conversation. My other channel says, in discovery, can you request emails that were sent or received in reference to the plaintiff? Sure. If you can argue that they're relevant to this case, I don't see why not. Nolan, I will try unplugging the sign. I have tried unplugging the sign before, and it did not help. OC House says, is my employer asking me to sit down with a man who injured me to work things out amicably before it gets ugly, as I said, a threat? I don't think it's a threat. I mean, I guess I can see why you might see it as a threat. I don't know. I mean, I guess depends the definition of a threat. Like, do you mean a threat of bodily harm? What did the person attack you? Did the person like run over your foot with a stock loader? Like, what are we talking about? You know? John Doe. John Doe says, how often do employers settle after the EEOC complaints filing before the answer is due? Well, I guess the best answer I can provide would be about 15% of our caseload resolves in the first 3 months. So most of those would be prior to the position statement. It's probably the best data I can give you on that. Mimi T says, turning the sign off did not change anything for me. Thank you for letting me know. My other channel says, on my Android phone, I hear the static, but on my desktop computer, there's no static. This is so fascinating. This is crazy. I don't want to use ableist language. I keep saying crazy lately, but it's very frustrating, these audio issues. Is Team Tahoe, is the clicking there now? We should have at least got rid of the clicking. Are you all hearing clicking? I've spent like $3,500 to get rid of the click. I cannot. I'm losing my mind with the click. John Doe KCK says, Vince, relating to earlier SM videos, can rules of evidence relating to it being more prejudicial than probative be used to keep SM postings out of admin proceedings in court? I don't. John Doe, can you write that question again without the shortened words so I can read the whole thing and understand it as a whole? Nolan, so I'll read what Nolan says. Nolan says, watch Hassan Minaj's reply to that whole situation, which I thought was fair. Young Turks painted him in a worse light than I thought was fair. Just my opinion. So I will say, I do think the Young Turks, one, I think it's a propaganda show. I don't think that's a news show at all. It's basically The View. Young Turks is just The View. It's not a good show. I don't trust them at all. I get a lot of clips because from them, because I think that YouTube thinks that I will really like Young Turks, and every time I see their stuff, I'm like, no, that doesn't. They say so many things that just don't make sense. I get frustrated with the Young Turks. So I could certainly see the Young Turks being unfair to Hassan Minaj. And my stance on Hassan Minaj is I like Hassan Minaj. I think he's a talented guy. Maybe I don't understand that situation to the extent that he lied about dropping some kind of white powder on his baby for attention. Obviously, I detest that. And it makes me think less of him as a human being, but who knows? Maybe that didn't happen. All right. I think we have 9 minutes left. I may not finish all these questions, so no further questions. John Doe, the truck is not plugged in right now, but I did. That's a great point. I should think about unplugging the electric truck because the electric truck would be directly below me. So that's possible. That's possible. There's a pretty sizable electric charging station straight down below me. Regina Johnson says, thanks, Vince. Happy weekend. You too. Anish, if you don't sign a verbal, they can terminate you potentially. You can sign the verbal and sign it saying just to admit that you received it. You don't have to agree with it, but they could have a pretext to terminate you for being for refusing to cooperate, being insubordinate. E&Y says, if I'm issued a probable cause in my favor, how long does it take between mediation or how long does it take between mediation or trial to be set up by the New York City Commission on Human Rights? Usually less than 4 months. You'll have a hearing. They're a little overwhelmed right now. May HM says, my lawyer mentioned the defendant will likely subpoena my current employer for the records on me. What will this mean for my employer? Almost nothing. I mean, the thing it'll mean for your employer is they'll wonder what's going on. But in terms of getting your records, it's not a big deal. Your attorney can fight that for the record. That's kind of aggressive on the defendant's part. So I think your attorney should fight that. Cuppy J says, thank you, Vincent. Thank you, Cuppy J. Thank you for being here. I hope that you like the live stream. We've got 7 minutes left. Nolan says, well, I think that the reason they were trying to induce resignation was because my son's using diagnosis caused my absences, then gave me assignments that I was too old to handle. So listen, that sounds like I'm hearing family status. I'm hearing FMLA impacted. I'm hearing, depending what state you're in, some state laws. Maybe an age claim as well. There's a whole bunch there. Matthew, besides Thomson Reuters, what legal tools do you particularly use, including AI legal tools? Side note, conceptually, I figured out a tool for your discrimination doxing need. I do not dox people. That is not something I engage in. I do worry about people doxing me. Matthew, I actually cut ties with Thomson Reuters. I do not think they are a good organization. We had a bit of a spat. We've been with them for, like 14 years, I think, off and on. And then like last August, they came to me and they're like, hey, you owe us $21,000. I was like, no, we don't. We pay our bill every month. What are you talking about? They're like, no. Someone went on your account and looked up something in another state. I was like, okay. I don't think that happened, but why would that cost $21,000? Like, well, they left it open for weeks and it runs, the clock runs because it's extra research. So the clock runs, they just left it open. And I was like, yeah, I'm not going to pay you $21,000. That's just on principle. You're not getting that 21 grand. I don't think you can prove that it was. They also said that it was on my credentials, and I don't. That did not happen. Like, I could assure you, I did not look up that thing. So I was just like, yeah. So like, your best case scenario here is somebody stole my credentials and used them, and like, I'm not paying for that, and I'm also not buying for a second that I owe you $21,000 because you claim this was left open for weeks and you like had the clock running like that. All that's insane. I don't think Thomson Reuters is very good. We're at LexisNexis now. And I got to be honest, I specifically declined the LexisNexis AI services. They were free, but I looked into them. They seem stupid. Like they're not there yet. In my opinion, based on my experience. And I've met with people about like custom AI solutions for our firm, and I have not been impressed. Like AI will absolutely replace some associates someday, some contract attorneys, some drafting attorneys, right? They will be replaced. That day is like 5 to 10 years from now. It is not today. Joe Mama says, Joe Mama. Hi, Vince. First, thank you so much for all you do. It's my pleasure. I hope it's useful. I am a federal employee in a formal stage of EEOC complaint on many instances and years-long abuse from a supervisor, discrimination, harassment. I am sorry to hear that. Is there more to that? Let me... In HD Films, I just saw your question. I've already made you a video on this. It's going to post, I think, this weekend or Monday. But I made you a long-form video answering your question. I'm really glad to hear, Team Tahoe, there's no more clicking. Nolan, if you run across that Hassan Minaj video and you want to throw it on a comment section on one of my videos, I would love to see it. Hey, Nintendo Slim, great username, always. BMM says the opposing counsel sent a pre-hearing statement and cited a couple of wrong dates that I had entered in my declaration. I never noticed them before. Any advice, please respond. You can probably deal with those. Like, listen, if you need to amend, you can amend, but you may not need to amend. You may just be able to deal with it like, hey, people make mistakes, right? This username begins with triple K, which I assume is not as problematic as it seems. So we're just going to say YYYMMM says, I have an ongoing EEOC charge. I would like to take medical leave. I am eligible. How much would I need to disclose to HR about my psychiatrist care? Can I take a full 12 weeks? Yeah, you just need an accommodation letter. I mean, just follow the FMLA process. They should have FMLA paperwork you can fill out. Your psychiatrist can fill out. It shouldn't be a problem. OC House says, is it a good sign that a lawyer took my case in a hybrid payment plan of a flat fee up front and a contingency on the back? He's the best employment lawyer in the state from reviews I read in ABO. Yeah, I have no problem with hybrid plans. So like a lot of attorneys in this field have really found that doing pure contingency work, the clients tend to be a little bit abusive. So like I'll use New York as an example. Most of the firms in New York move to hybrid. They charge some flat rate up front and then contingency percentage on the back end. And I don't know what it is, but all of them who do that say that the quality of life is just through the roof better than it was when they were doing pure contingency. So I'm not at all concerned by that payment arrangement. Okay, it is 5:29. Oh, hold on. Joe Mama, where's the second part of your question? Let me finish answering your question before I go. Let me find it. Let me find it. Where is it? Okay. Joe Mama went on to, so Joe Mama is a federal employee who's engaged in the federal employee EEOC process, the formal process. I still report to this person and fellow abusers. Is a failure to separate me from my abusive supervisor chain another claim or demonstrative of ongoing harm? Well, I think you can demonstrate ongoing harm, right? I mean, I think it increases your damages, certainly. I don't know that it's necessarily a separate claim. I would say it more substantiates your damages on this claim. Listen, there's some questions. Ted Zinro, I see your question. I'm sorry, I don't have time to answer it. If you ask it in a comment section on a video, I will look for it and I will create you a video. I'm sorry, I'm not trying to dodge your question. John Doe, I think I missed some of your questions here. There's a lot of questions here. Okay, I gotta go. I'm sorry. Oh, I love this last question. Corey said, I love this question. Corey says, hi, does it matter what school the lawyer went to, like a big school versus little school lawyers to have on your side? I would say to you, if you're hiring a law school professor or a defense attorney, the pedigree of the law school matters. If you're hiring a plaintiff side attorney, the law school matters not at all, because plaintiff side attorneys work a lot of cases and you can see their work. You can go on ECF, you can go on Pacer, you can look at the press their cases generate. You can get a feel for what they've done and the quality of their work. So I would argue that for them, the quality of their law school does not matter at all. Now, full disclosure, my law school is like not great. It's like, I think it might still be top 100, but it's not setting the world on fire. It's not like top 20. Let me tell you that for sure. When I went to that law school, it was way higher rated when I like got a scholarship there. And then it just like straight tanked. Like they just yeet deans out of the law school over and over and over again. And they get a bunch of no-name deans, and the school's not run. They had a dean who was a drunk for a while who would go around saying things like, we're going to do law school in 2 years. And it's just like, no, you're not. That was never true. Why are you saying these things? And it really hurt the ranking of the law school. But it is a really good labor and employment law school. And it was really good. Like I had a great professor. I was a securities major, actually in law school. I did securities compliance and investment. And my first gig was at an investment bank. And I had this amazing professor, Scott Colasanti, who taught me so much and took so much time with me. So like, listen, I loved my law school. I loved my law school experience. I loved my scholarship. I will say my law school did some really shitty things. Like they took everybody who had a scholarship and grouped us in the same small section of like, I don't know, like 40 people and curved us all together. So by definition, everyone had a scholarship. Only the top 20% got to keep their scholarship. Like after the first year, I kept mine. But what what a dirty move. Also, and this was wild too, I had student loans, and my law school, they would keep your student loans locked in their interest-bearing account. Allegedly, this is what I was told by their own financial people. So they would not give you your law school, like your student loans. They would keep them in their interest-bearing account, allegedly, and get interest off them, and then give them to you like after the semester. So there was times where like I couldn't buy food in law school. Like I was working. Part of the reason why I continued working in bars as a bouncer through law school was because my law school wouldn't give me the student loans that the federal government had already funded. So I don't think love my law school experience, hate some of the things my law school did. I don't think the size or the pedigree of the law school matters for plaintiff side attorney. I do think it matters for other realms of law, but not for plaintiff side. Thank you so much, everybody. I hope I helped. I got to go. I'm so sorry. Take care, everybody. I'll do another live stream in like 2 weeks. Bye. Like, subscribe, comment down below, share the channel so it can grow.